we need to have a look at the statutes, and the most important statute that we have in construction now, and prior to 1996 it was a very different landscape. So in 1996 we had the Housing Grants and Regeneration Act was issued, and the intention of the Act of Parliament was plain. It was to introduce a speedy mechanism for settling disputes in construction contracts on a provisional interim basis, and requires the decisions of the adjudicator to be enforced pending final determination of disputes by arbitration. So prior to 1996, the only way you could settle a dispute in regards to a construction contract would have been through litigation in the courts or arbitration. So they introduced the Adjudication Act to have a process that we could settle disputes a lot quicker than you go through the 2 or 3 years you spend doing litigation. So if you've ever heard of the Adjudication Act, I would hope the QSs and the commercial guys would have heard about adjudication. So the next one's a question for those that may or may not know. So how quickly do you think an adjudication is supposed to take from the date that you issue the notice of intention to adjudicate to the date of the decision that you get from the adjudicator? So okay, so that's not a bad guess. So the number of weeks that it takes from notice to decision, the minimum period that it could be would be 4 weeks, and the maximum period that it's supposed to be is 6 weeks. So once you've issued your notice, then you issue the notice to the adjudicator and to the other side. The other side then has a period then to respond to that notice. You generally have a period to reply, then the adjudicator makes a decision. So somewhere around 4 to 8 weeks would be a reasonable estimate for the number of weeks for something that used to take sometimes 2 or 3 years to decide. So adjudication is statutory, so it's written into the statute, which means that every construction contract that you have the right to adjudicate. Whether it says so or not in the contract, you have a right to go to adjudication. So as long as the contract that you're working on is a construction contract, if you're working on maybe on a processing plant or a process contract, or you're working on a factory or some other type of contract which may not be defined as a construction contract, then it may not apply. But if you work on a construction contract, then you have an express right to use adjudication to settle your disputes. And if the contract that you sign up to does not contain all of the statutory adjudication rights that you have, then you get those automatically. You can't start writing out parts of Adjudication Act because it's all set in statute for you already. So there's 2 parts to the scheme. So we've got part 1 of the scheme. So part 1 of the scheme, if the contract doesn't comply, so if you have a contract that doesn't comply with the right wording, then the adjudication provisions of the scheme for construction contracts apply. So if they're silent in respect of your dispute resolution solutions in regards to adjudication, then that wouldn't comply. So that means that the scheme applies. And even if non-compliant is partial, the whole of the scheme. So if they put in part of it but not all of it, then the scheme comes in lock, stock and barrel. So that was Uganda UK Limited and WW Gear case, where there was some issues in regards to the project, and I'll pick those up now just to explain. So the claimant was a contractor that was instructed to install a glazed curtain wall in a hotel constructed by the defendant. The contract was a JCT, and it had been amended to the extent that the entire provisions related to adjudication were deleted and replaced with a clause which, amongst other things, said that should the claimant bring any issue to adjudication, it will be responsible for all of its and the defendant's costs, irrespective of the outcome of adjudication. So what they've tried to do, they struck through all that standard boilerplate wording in the JCT, and they started to introduce new clauses and new ways of dealing with adjudication. And it also said that interest for late payment should be set at 0.5% above base rate. So the claimant sort of declaration to say the amended provisions were void, and they asked the judge as to how they should be replaced. So the issues here was that the amended clauses were they in compliance with the Act, and if they were not, what should replace them? And also, were the interest changes in compliance with the Late Payment of Commercial Debts Act 1998? So what do you think the judge decided to do? It's another one of those questions. So did he say, do you know what, those provisions relating to adjudication should be deleted and then replaced with those in the Act? Or did he say, well, you know what, I agree with what they've done. The defendant should be responsible for all of the costs of the adjudication for both parties. Or do you think that the contract should be amended and incorporate the provisions contained in the scheme? So what do you think? A mixed bag, right? So that they could be deleted and replaced. Yeah. Okay. So what happened? So the 1996 Act did not contain any provisions as to costs and how costs should be paid in regards to adjudication, other than that the adjudicator had the authority to award costs. So what they said is that these changes that have been proposed by the claimant have the effect of bringing a situation round that if you don't have enough money to pay your own costs and the other side's costs, then you can't actually do an adjudication in the first place because you won't be able to afford to do one. So what they said was that clause, it could prevent you from bringing a claim, effectively bringing a claim. So the clause should be replaced by the adjudication provisions contained in the scheme. So yes, they were deleted and they were replaced with the provisions within the scheme. The contract interest rate, they said, well, you know what, the parties have negotiated a rate between them. So whilst that rate is different to what's in the Late Payment and Construction Act, as they've negotiated between the parties, they didn't think they should have to change that. So it was a half and half. So in regards to costs, you only pay your own costs. You don't pay the other side's costs. If they put a clause into your contract to say to you, if you want to adjudicate, you've got to pay our cost as well as your own, that is nonsense. It will not carry. You only pay your own costs of adjudication. You can't recover those costs through the adjudication, but you only pay your own costs. And the only person who can decide who's going to pay any cost to anybody is going to be the adjudicator, and that will not include the costs of bringing an adjudication. So the next part of the Housing Grants Act, which amazingly wasn't in place before this, was that contractors have a statutory right to interim payments unless the works are less than 45 days long. So, and there must be a way of calculating what those payments are due, how much they are, and when they fall due. And there can't be any conditional payments within a contract. And any contract must contain provisions for a payer's notice, a payee's notice, and a pay less notice. Up until then, we had things like paid, when the client would say, well, I'm not paying you till I've got paid, or the contractors, I'm not paying you till I've been paid, and you've asked for 100,000 and I've been paid 20, so I'm only going to give you 20. So now you have a right to get paid on an interim basis, which is generally a monthly basis, against the works done on the project. So part 2 set out some changes in regards to the payment, dealt with the payment provisions. So if you don't have those payment provisions in your contract, then the statute will impose those, just as they've imposed those conditions in regards on part 1 of the Act in regards to changes that are made. You can then impose these payment provisions as part 2 into your contract. There was a case that reinforced this in Bennett Construction and CIMC MBS. The contract had a situation where there were payments that were required on sign-off, which wasn't particularly well defined. And the Act says that you're not supposed to have conditional payments. So what happened is there was a hotel being built in East London, and Bennett was the main contractor, and they asked CIMC to design, supply and install prefabricated modular bedroom units for the hotel, which were made in China and were being shipped to Southampton. So the contract between Bennett and CIMC was a standard JCT, and there were some interim payment provisions, but some of them were also replaced by new provisions that says you're going to have some milestone payments. And two of these milestone payments were stated as payable on sign off of a prototype room of the bedroom units that are being supplied. So the question was being asked is whether are these payments conditional payments, and if they are conditional payments, then they shouldn't be allowed under the Act. So there's a number of disputes about the bedroom units and whether they had defects in the units, and as a result, the units were never actually signed off and were never formally acknowledged as being complete, but they were shipped to the UK at CIMC's own risk, following some without prejudice payments made by Bennett. But ultimately, as often happens in these situations, the contract came to an end, the developer had to be liquidated, and the units were all scrapped. So there was an adjudication in Bennett's favour that CIMC then said, well, you know, we're still not happy that these payments on sign-off could be milestone payments, and we don't think we're compliant with the Act. So they trundled off to court again, and the judge found that milestone payments requiring sign-off by Bennett and others were non-compliant with the Act. And he said, well, you can't have these kinds of situations in regards to your contract. So you can't alter those milestones, you can't change those milestones. So Bennett said, well, hang on a minute, that's not right, because you know what, we can't be paying for stuff we haven't signed off. Anyhow, it ends up going to the Court of Appeal, and the judge Coulson, the lead judge Coulson at Court of Appeal, said that those sign-offs were an adequate method of using the contract. So whilst the Adjudication Act says there should be no conditional payments, if you've got something in your contract about sign-off payments or milestone payments and you're concerned about those, then it's probably worth you getting some legal advice before you sign that contract, because you may find you might get to the end, and if those things haven't been signed off, you may find you might not get any money. So as in all these things in the law, there's never a straightforward answer.